All right, good morning, everybody. We are going to go ahead and get started here. It's 10:02. I know everyone's busy. So, thank you again, everyone, for attending. This is the Texas Residential Construction Liability Act 101 CE course. Again, my name is Mark Solomon. I'm the managing partner of Mathieson, Wickert, and Lair's Austin, Texas office. For those of you that don't know about the firm, brief overview. We are a national subrogation and full service insurance litigation firm. Our headquarters are in Hartford, Wisconsin, just outside Milwaukee. We've got offices in Austin, Texas, where I am located, in New Orleans, Louisiana, Jacksonville, Florida, and in Orange County, California. So we are truly coast to coast, nationwide subrogation firm with about 30 lawyers and 100 staff, handling all aspects of property, auto, healthcare subrogation. A bit about myself: I grew up in Albuquerque, New Mexico, moved to Austin to go to undergrad at the University of Texas, was here for 4 years, and then moved down to Houston, attended law school at South Texas College of Law, was in Houston for about 12 years doing insurance defense and subrogation work down there, moved back to Austin to work in-house counsel for an insurance company here, running their subrogation, in-house subrogation law firm, and then joined Mathieson, Wickert, and Lair about 2.5 years ago to get the Austin office started. And that being said, let's go ahead and get started. All right, what is the RCLA? And for ease of me not having to repeat, the Residential Construction Liability Act 50 times today, I'm just going to call it the RCLA. So it stems from Texas Property Code in Chapter 27. And basically, it's a statute that lays out the provisions and requirements to pursue a claim stemming from a residential construction liability. So what does all that mean? There's a ton of definitions because our lawmakers are good at doing that. We'll read through them. I know it's going to be a little bit long and tedious, but it's pretty important that we realize what these are. So in the beginning of the Act, construction defect, Section A in this title, a construction defect means the following. It is the failure of the design, construction, or repair of a home, or an alteration of, or a repair, addition, or improvement to an existing home, or an appurtenance to a home to meet the applicable warranty and building and performance standards during the applicable warranty period. And here we go, any physical damage to the home, an appurtenance to the home, or real property on which the home or appurtenance is affixed that is approximately caused by that failure. So in layman's terms, it is a defect from your house, whether it is a new home or an alteration of a repair to an existing home. This also applies to maybe a barn or a shed or anything else that you have on your property that can be considered part of the residence, and any defect that goes there too. B, the term does not include a defect that arises or any damages that arise wholly or partly from the following: the negligence of a person either other than the builder or an agent, employee, subcontractor, or supplier of the builder. And then it also does not apply the failure of a person other than a builder or an agent, employee, subcontractor, or supplier of that builder to do the following: take reasonable action to mitigate any damages that arise from a defect, or B, take reasonable action to maintain the home. The term does not include a defect that includes normal wear, tear, or deterioration. And the defect does not include normal shrinkage due to drying or settlement of construction components within the tolerance of building and performance standards. Basically, that means if there's normal settling in your foundation, that is not going to be included. So the RCLA was passed when Governor Perry was governor of Texas. It was basically, it's a very construction and contractor friendly statute. It puts a lot of hurdles in terms of us in the subrogation world to recover on these claims, because it makes it very difficult, because there's a lot of timeliness and notice issues that must be complied with. And what happens is you end up kind of in conflict with your insureds, because your insureds, they want their house fixed. And of course, us subrogation professionals, we want to get the money back for our employers. And sometimes that comes to a head in terms of this, and the RCLA is that kind of wedge in that whole deal. So we'll go through a lot more of what all this means and real world application to that. So construction defect, it applies, and for any other action means a matter concerning the design, construction, or repair of a new residence, or an alteration of a repair or addition to an existing residence, or of the appurtenance thereto. The term may include any physical damage to that residence, any appurtenance or to the real property on which the residence and appurtenance are affixed, approximately caused by that construction defect. So, to put it simply, it is a construction or alteration of a, quote, residence. So, of course, we need to go to what is a residence. A residence means the real property and the improvements for a single family house, a duplex, a triplex, or quadruplex, or a unit and the common elements in a multi-unit residential structure in which title to the individual units is transferred to the owners under a condo or cooperative system. So it doesn't really mean apartment complexes. This is more contemplation of your single family homes, your townhomes, and condos where individual owners actually own the units versus a leasing company who owns a big multiple apartment complex with multiple units. So let's figure out what claims will the RCLA ultimately apply to. Section 2702 of the chapter deals with the application of the RCLA. So this chapter applies to any action to recover damages or other relief arising from a construction defect, which we previously defined, except a claim for personal injury, survival, or wrongful death, or for damage to goods. And it does apply to any subsequent purchaser of a residence who files a claim against a contractor. So if you are the second or third owner of a house and there is a construction defect, you are still able to recover, obviously given you need to comply with the statute of repose, but it doesn't mean that if you're not the original owner or your insurers are not the original owner, that they are going to be barred from recovery under the RCLA. It does mean, however, that they will be bound by the same terms and conditions of the RCLA. And we'll get into those more about how it deals with notice and what's required. So moving on, let's talk about the keys to a successful RCLA claim. And what I mean here is that if you fail to comply with the RCLA, you're going to be delayed in terms of recovery. And then most of the time, what ultimately ends up happening is you end up with a spoliation type charge against you if you've done all these repairs to the residence before the builders have had a chance to inspect. And again, we talked earlier, touched briefly on what that means in terms of your insured who has a flood in their house and wants their house fixed, versus you saying, hey, we've got to wait all this time to allow them to inspect because we want to get our money back. And so again, it makes it difficult at times, but we need to make sure we deal with all the notice and all the timeliness requirements that we have here. So moving forward, notice. This is it is the most important aspect of this. And so notice, before the 60th day preceding the date, a claimant, this would be us, seeking from a contractor damages or other relief arising from a construction defect, initiates an action. So what that means is 60 days prior to filing suit, someone seeking damages from a contractor has to. So here we go. The claimant shall give written notice by, this is very important, certified mail, return receipt requested to that contractor at the contractor's last known address, specifying in reasonable detail the construction defects that are the subject of the complaint. So you need to send a certified written notice to the contract that says, "Dear Charlie contractor, you were defective in the construction of the residence," list the address, and list the defects out in reasonable detail. I would give it more than reasonable detail. I'd give express detail because you want to make sure that they have everything in front of them, that they know what the defects that you are claiming and what the damages are going to be. So once that notice gets sent, the contractor has the option to request from you or your insured. The claimant, on the request of the contractor, the claimant shall provide to that contractor any evidence that depicts the nature and cause of the defect and the nature and extent of repairs necessary to remedy the defect, including, this is important, expert reports, photographs, and videotapes, if that evidence would be discoverable under the rules of Texas Rules of Civil Procedure. So the key there is your expert reports, photos, and videotapes. Typically in litigation, those get held back until the docket control order sends those out, or the new discovery rules make sure that they're required as part of the disclosure. And so basically you have to turn over your evidence of the defect to the contractor if they request it. Now the key there is on the request of. So you just need to make sure that they're doing that. But the nice part about subro, and we all know this, is typically if you're in the subrogation department and a file's on your desk, most of the time liability is going to be against the other guy, just because we know that, and that's why we are in subro. That's why we're subro professionals. So we're going to have a lot of dates here. I will go through kind of a sample timeline later in the presentation, so you can kind of see the dates of how these work. They obviously change based on how long it takes people to get and receive the notice. So here we go. During the 35-day period after the date the contractor receives, here's a key here, is when they receive it, not when you mail it. That's a little different than the litigation world, that things are deemed served when you mail them, not when they receive them. This is the opposite. So 35-day period after the contractor receives the notice and on the contractor's written request, as we talked about. Now the contractor shall, as an ultimate right, be given a reasonable opportunity to inspect and have inspected the property that is the subject of the complaint to determine the nature and cause of the defect and the nature and extent of repairs necessary to remedy that defect. The contractor may take reasonable steps to document the defect. So you send the notice, the contractor receives that notice, they have 35 days to send you a written request that they be given a reasonable opportunity to inspect the property or send someone else to inspect the property. And then they get to determine the cause of the defect and basically get an estimate on the repairs to remedy that defect. And they have an opportunity to take photographs, videos, and whatever they can to document those damages. If proper notice is not given, the builder is allowed to abate the case until notice provisions are complied with. So if you just send a regular mail to the contractor and you end up in court, that contractor can ask the judge to stop the case where it is, and the case will stop until that 35-day period runs after they receive your certified notice. And so again, it's very important on notice to make sure that this notice is in writing and that the notice is sent certified mail with that return receipt request. So offer of settlement. So here we go to another deadline. So after they get a chance to inspect and the contractor takes a look at all the defects and they realize what they think the repairs are going to be, We've got another date. So 24007B, offer of settlement, not later than the 45th day after the date the contractor receives the notice. The contractor may make a written offer of settlement to the claimant. So this offer needs to be sent to the claimant at the claimant's last known address or to the claimant's attorney. And here, they have to do it the same as us by certified mail, return receipt requested. The offer may include either an agreement by the contractor to repair or have repaired by an independent contractor, partially or totally at the contractor's expense, or at a reduced rate to the claimant, any construction defect described in the notice and shall describe in reasonable detail the kind of repairs which will be made. So the contractor can now come in. They get 45 days after the notice to make you this written offer of settlement. And the whole thing here, and we'll get into this more, is going to be, is the offer reasonable? It's a reasonableness standard that the trier of fact ultimately will go to. But at this point, they can send you a written offer. In the event you accept those, the repairs shall be made not later than the 45th day after the date the contractor receives written notice of acceptance by you or the insured of the settlement offer, unless completion is delayed by the claimant or by other events beyond the control of the contractor. So if a hurricane rolls through, they don't get it. But so they send you a written offer, we accept it. That contractor has 45 days to make sure all the repairs are done. And so if we're keeping track, at some point we may be 90 days from the day the contractor received notice before those repairs are done. That may seem like a long time, and your insured certainly is going to think that is a very long time. So moving on with the settlement, there's more nuances to this. If a contractor makes a written offer of settlement that the claimant or professionals here considers to be unreasonable, we got another date, on or before the 25th day after the date the claimant receives the offer, not when it's sent. The claimant shall advise the contractor in writing and in reasonable detail the reasons why the claimant considers the offer unreasonable, and then not later than the 10th day after the date the contractor receives the notice that you are rejecting the offer under subdivision 1 above, the contractor may make a supplemental written offer of settlement to the claimant by sending the offer to the claimant or to the claimant's attorney. So it's basically a negotiation going back and forth. They send you an offer. You've got 25 days to reject it. And if you do reject it, you have to do that in writing and explain why you believe that the offer is unreasonable. That's the key here. And then they get a chance to come back within 10 days after receipt of your rejection to make another counteroffer. Now, while all this is going on, we talked about that 60-day time period. You can file suit while all this is happening, as long as it's been 60 days past when they received that offer. Now, the trier of fact will know about these offers. They will come into evidence, and they will be allowed to review these offers and to weigh the reasonableness of the offers that went back and forth. And so just understand that, typically settlement offers are not admissible in court. Under the RCLA, when you've got these and these written offers are made, they are admissible in terms of evidence of reasonableness of the offer once the trier of fact. This is probably not going to happen too often. You'll see this, but it has been contemplated by the Act. What do we do if we've got a statute that's approaching? So Section 27004D deals specifically with this. So if the giving of the notice under subsections A and B within the period prescribed by those subsections is impracticable because of the necessity of initiating an action at an earlier date to prevent the expiration of the statute of limitations, or if the complaint is asserted as a counterclaim, compliance with Subtitle D, Title 16, we're not even going to get into that today, or the notice is not required. Basically, it says if the statute is approaching and the 60-day time period is not feasible, you can go ahead and file that suit with kind of the caveat that, yes, the statute is approaching and we would waive that should we not have done that? And again, however, if the action or counterclaim, it shall specify in reasonable detail each construction defect that is the subject of the complaint. So basically, you need to put what notice you'd be required under subsections A and B to the contractor. You're going to need to describe that in the suit so that you're in compliance with that RCLA. So continuing on with the statute, the inspection, obviously what happens if we file before all that, the inspection provided for in subsection A may be made not later than the 75th day after the date of service of the suit, request for arbitration, or counterclaim on the contractor. And the offer provided for by subsection B, that offer of settlement, may be made not later than the 15th day after the date the state-sponsored inspection and dispute resolution process is completed, if subtitle D, Title 16 applies. We're not getting into that today. Or not later than the 60th day after the date of service, if subtitle D, Title 16 does not apply. So the second one is what we'll primarily be dealing with for those of us in the property sub. If, while an action subject to this chapter is pending, the statute of limitations for the cause of action would have expired, and it is determined that subsection A was not properly followed, the action shall be abated to allow compliance with subsections A and B. Basically, it says that the statute would not have ran and you filed too early. The case is abated to comply with the requirements under the timing that we discussed a little bit earlier. So what happens if we reject an offer? Subsection 27.004E deals specifically with this. So if a claimant rejects what is considered a reasonable offer made under subsection B, or does not permit the contractor or independent contractor a reasonable opportunity to inspect or repair the defect pursuant to an accepted offer of settlement, the claimant does the following. So they may not recover an amount in excess of one of the two things: the fair market value of the contractor's last offer of settlement under subsection B, or B, the amount of a reasonable monetary settlement or purchase offer made under subsection N. So if you do not permit the contractor to repair the defect pursuant to the accepted offer, you are limited in damages to the fair market value of the last offer of settlement that they made, regardless of whether the repairs are made or not. Or actually, the contractor can buy back the house for a purchase offer. I've actually seen this once. It was a very strange case, but the contractor actually came back and made an offer to buy back the house. Obviously, the client did not want that. They lived in the house. They had built the house and just moved into it a few months earlier. But we ended up getting that worked out. But yeah, they actually instilled this. I've seen this at work where the contractor can actually make a request to buy back the residence. It seems a little crazy that someone can just come in and buy your house back from you. But it does happen. So it's in there. So, and then also the claimant may recover only the amount of reasonable and necessary costs and attorney's fees as prescribed by Rule 1.04 of the Rules of Professional Conduct incurred before the offer was rejected or considered rejected. So under the RCLA, you are entitled to full recovery of attorney's fees because it kind of stems in a breach of contract type action. If this rejection is made, if repairs are not allowed to be made, your attorney's fees get cut off for anything after the offer was rejected or considered rejected. So you can actually end up kind of shooting yourself in the foot in terms of recovery of attorney's fees from doing that. Again, these are kind of one-offs. The goal here is that eventually, the contractor gets the notice of the defect, they inspect it, and they make reasonable repairs. Now, again, there's always a negotiation. All of us are going to have our own estimators and professionals who are going to make sure that our insured is being put back to where they were before the defect occurred. And so my guess is that usually our estimates and repair costs are going to be a little bit higher than that of the contractor, but it's always something that is negotiable in terms of getting them done. So, moving on to effect of, let's say the contractor makes zero offer. That is contemplated in Section F. If a contractor fails to make a reasonable offer under subsection B, the limitations on damages that we just discussed in subsection E will not apply. So if they make no offer, they actually don't have any opportunity to reduce their damages or to buy the house back. And the key here is the trier of fact, whether that be the judge in a bench trial or the jury in a jury trial, will determine the reasonableness of an offer for purposes of the RCLA. And so basically it's, the law is wanting folks to act in a reasonable nature. They want folks to try to get these resolved, to give everyone ample opportunity to inspect, to repair, and to get those repairs done in hopes of avoiding litigation. The 60-day time period puts a big hump on that in terms of, letting people kind of cool off. It's almost a cool off period to try to look at these things rationally. But again, the trier of fact is ultimately going to determine the reasonableness of this. If your estimates are only a couple $1,000 apart, it's going to be reasonable. If the contractor comes back and his estimate is 1/10 what yours is, most reasonable juries are going to say that's not reasonable. So we're talking about all this and the damages. Well, now what can we get under the Act? What damages are recoverable under the RCLA? So always an exception, except as provided by subsection E. In an action subject to this chapter, the RCLA, a claimant may recover only the following economic damages approximately caused by a construction defect. First being the reasonable cost of repairs necessary to cure any construction defect. Two, the reasonable and necessary cost for the replacement or the repair of any damaged goods within the residence, obviously your personal property, and the cost of repairs. The reasonable and necessary engineering consulting fees. So your expert fees, your CNOs, your electrical engineers, whatever it may be, those fees are recoverable as long as they are reasonable. And then reasonable expenses of temporary housing that are reasonably necessary during the repair period. So your ALE is also recoverable under the RCLA. And then the reduction in current market value, if any, after the construction defect is repaired, if the construction defect is a structural failure. So basically, if you've got settling due to a construction defect, or something has gone really wrong with the foundation or supports in the house, you are able to recover that reduction in the market value. This is going to be a very rare occasion you're going to see that. And then, of course, as we discussed just a few minutes ago, the reasonable and necessary attorney's fees on there. So moving on to additional damages that are recoverable and what are not. You must be able to prove up the damages were both reasonable and necessary. The key here is to make sure you keep all invoices and receipts. The only damages you are entitled to are liquidated damages. There's no such thing, and we'll get into this on the next slide. So the damage is not recoverable. Your mental anguish, not there. Your business interruption, if you have a home business, not recoverable. Your moving and storage fees, and then pet boarding, also not recoverable. An interesting aspect in looking at this is, this statute was passed well in advance of COVID and 90% of the world working from home in some capacity. It'd be interesting to see what happens if someone claims some business interruption on this home business, or whether this statute ultimately gets amended to allow for something like that, just because so many people now are working from home. The world's kind of changed in terms of what that means. So I had mentioned earlier about going through kind of a sample timeline and how we are going to look at these things. So I set up as simple as I could in terms of looking at the deadlines and kind of just getting an idea You can talk with your insureds about with how long the process may take under the RCLA. So let's just say January 1, for ease of this talk, you send the notice to the builder. Okay, and I've got remember requirements here because again, it's got to be in writing, got to be sent certified mail return receipt request. So let's just say the Postal Service takes until January 5th for the builder to receive that notice, right? They'll sign that green card, you'll get it back, it'll be dated. And so January 5th will start all of your timelines because remember, it's not the day the notice was sent, it's the day the notice is received. So we do 35 days from January 5th. We're already at February 9th, and that is the deadline for the builder to request that inspection. They also have to do that in writing, certified mail. It's either to you or your attorney. And then 45 days after the notice is received, we're now at February 19th, and that's the deadline for the builder to make an offer. And that offer, again, needs to be in writing, and it's got to be detailed. Intervene here. Earliest day to file suit, 60 days after the notice received. So we're at March 6th. So we send that notice on January 1. It's received January 5th. March 6th is the earliest day that we can go ahead and bring this contractor into court. So that's kind of the intervention day. March 16th, that's the deadline for us to accept or reject that offer. So that's, again, 25 days after the offer is received. And then 10 more days after that, we're at March 26th, and the deadline for the builder to make their supplemental offer. So this is kind of a very, very general overview. You can see, we're almost into April by the time we deal with the timelines, should they go to the maximum amount of time. Now, obviously, if the builder requests the inspection 3 days after they receive notice, it's going to speed everything up. They still have got that 45 days to make that offer, but ideally, right, the builder makes their inspection, they make the offer quicker. And then that kind of speeds up the deadlines of, your 25 days after you've got the offer, you get to reject it, and then the 10 days for the counter. So this is kind of a worst case scenario, but it's something you'd need to explain to your insureds that, it may take, we're looking here basically 90 days to have anything really moving forward until that. Yeah, March 26th, by my calculations, I think it's 86 days for us to really have anything moving under the RCLA. Now, again, the effect of all this is that, you may waive your homeowner's claims when a contractor's involved. And everybody that is in this industry knows that the homeowner's claims can get large in a hurry, and that waiving that can be a huge, huge downfall to you and your company and your subrogation departments. So making sure that we are in compliance with this RCLA, things that you'll need to understand. And a couple questions, we'll address these, but house is an imminent threat to the health and safety of the residents. So your house is flooded or it's a dangerous condition. 27004M deals with that. So notwithstanding A, B, and C, a contractor who receives a written notice of a construction defect resulting from work performed by the contractor or an agent, employee, or subcontractor of the contractor and creating an imminent threat to the health or safety of the inhabitants of the residence shall take reasonable steps to cure the defect as soon as practicable. If the contractor fails to cure the defect in a reasonable time, the owner of the residence may have the defect cured and may recover from the contractor the reasonable cost of the repairs, plus attorney's fees and costs, in addition to any other damages recoverable under any law not inconsistent with the provisions of this chapter. So, if there's an imminent threat to the health or safety, the contractor needs to act quickly. If they don't, the homeowner or the insurance company in this case has the ability to have that defect cured and recover those damages. One big thing I'm sure people are thinking in their head is that if you've got a flood, you've got a duty to mitigate that damage, because in Texas, where it's humid and hot, mold is a major issue. And so mitigating those damages and not allowing mold to spread throughout your house is going to be considered reasonable, right? If you don't do that, a jury's going to say, well, you just let it sit there knowing that we're going to take 86 days to get the suit after this notice, and now the house is completely just a total loss because the mold is so spread out. So, yes, you've got a duty to mitigate the damages, and you can fix and repair the damages that are necessary for the health and safety of the people who live there. We talked a bit about the builder offer to purchase back the residence. 27004N is in Nancy. The section does not preclude a contractor from making a monetary settlement offer or an offer to purchase the residence. So they can purchase the house back, or they can make you just a lump sum offer to try to get it resolved, and you can do the repairs yourself. And then 27042 talks about a conditional sale to the builder. We're not going to get into that. Again, it's so rare you're going to see it. I just need to bring it to your attention. So what happens if the builder refuses to start repairs? 27004Q, if a contractor refuses to initiate repairs under an accepted offer made under this section, the limitations on damages provided for in this section shall not apply. So your damages, if the contractor refuses to initiate those repairs after you've accepted, the damages don't get limited, they can increase. And then mandatory mediation, if a claimant files suit seeking from a contractor damages arising from a construction defect in an amount greater than $7,500, that's pretty much going to be every case the homeowner's lost. The claimant or the contractor, so either party, may file a motion to compel mediation of the dispute, and the motion must be filed not later than the 90th day after the date the suit is filed. So mediation can be mandatory under the Act. Again, you've only got 90 days from the date the suit is filed to do that. I don't quite know what would happen if for some reason it took you 91 days to serve the contractor after you filed the suit. You know, would this provision then be waived? Don't really know how that would work. My guess is the court is going to allow that to go through, but we all know most courts today are requiring mediation. It's a great way to get these cases resolved and keep costs and expenses down for both sides. So just know that they can demand mediation, and you have to comply with that under the Act. So I am going to address some of the questions that we've got. I always leave a few minutes at this presentation to do some questions. Please know that if you've got additional questions, I know this is a very confusing area of the law, and the notice deadlines and everything that go with it are tough to calculate. And so I'm happy to talk with you. You can give me a call, you can email me, and we can set up a time, or we can talk after this, after the presentation ends, and I'll be happy to address any questions. So the first one, Fran Brooks writes, are temporary repairs allowed to mitigate your damages? Fran, yes, you can do those repairs. Again, the health and safety type deal. It's going to be a reasonableness standard under this. You know, as long as you can justify why you're doing this. Yes, you drilled holes in the wall and cut out, you know, floorboards and drywall because there was water damage. You didn't want mold. That's going to be okay. Leslie Klotz writes, if the damage is repaired due to mitigation and the contractor does not have an opportunity to inspect, can the subrogation go forward? Yes, Leslie, on this, it's kind of, you know, the same deal that if you are mitigating damages for health and safety, those are going to be allowed. Obviously, you are going to be better off if you can photograph, video, document all these damages so that you can show those to a trier of fact. The reasonableness standard is what we're going to continue to be bound by under the Act. And so as long as you can show, hey, it's reasonable, and you can explain to a jury, this is why we did this, there was a health and safety threat, and we're trying to mitigate our damages, then it's going to be okay to do those. Again, they just need to be well documented and with enough, you know, camera experts and all that, doing such a good job these days with videoing scenes and using drones and doing all that. Most of the time, that's not going to be an issue. David Combs writes, does RCLA only apply to construction defects, or does it also apply to acts of negligence? It's going to be that construction defect, David, which is defined earlier. It's kind of hard to separate those because usually the defect is going to stem from some negligent act, so they're kind of one and of the same. But there may be an independent act of negligence which may not apply under the RCLA. That's going to be a one-off situation, and that'd be something that we'd need to discuss on a case-by-case basis. But I don't think you're ever going to go wrong in putting a case under the RCLA just to be safe. I don't really see any harm that's going to come from it if you're in compliance with the statute every time. The only real harm you're going to be is if it's not in compliance. Paul Lipsy writes, who determines if it is an imminent threat? Paul, it's going to be a completely subjective call. It's going to be a reasonableness standard. Again, if it looks like the ceiling's going to fall and you need to shore it up, then that's going to be an imminent threat, right? If it looks like mold's going to generate, that's going to be an imminent threat. If you're missing a few bricks off the side of your house and doesn't look like anything's going to happen, obviously not going to be an imminent threat. So it's just a subjective standard in terms of who determines if it's an imminent threat. It's basically, would you think a jury of your 12 peers would agree with you that this is an imminent threat to the health and safety of the folks who live at the residence? Maria Romero writes, what happens if the contractor doesn't accept the certified written notice? That is going to happen from time to time, Maria. So one thing you can do is, another way I think you'd get around this, or not get around it, but be in compliance if they refuse to accept it, would be to serve the registered agent with it. We can find that through the Texas Secretary of State. If they're a registered corporation, they will have a registered agent. You may even have to go so far as to maybe personally serve them. I mean, you would probably need an affidavit if you have someone who is just a one-off contractor, not incorporated, who's just a guy doing work. You might need to serve him with service of process. And I think what would happen is that the court would look and you'd say, hey, listen, we sent the certified mail, it came back. We tried it a couple times, it came back. He refused to pick it up. So we served him with it. You might also have a judge that says, hey, listen, if you sent it certified in U.S. mail and they refuse to pick it up, that's on them. I think it'd be safer to get it in their hands, but if they refuse to pick up that certified mail, generally a court's going to look at it and say you've done your diligence under the statute. It's not on them. It's now on them to pick up their mail, as long as you can show you sent it to the last known address. Let's see. Paul writes, will the handout be available for reference? Yes, I think that's been sent by Jamie, our organizer. If you don't have that, let us know and we'll get that. And then Jamie Glanz writes, a cheat sheet of the dates and timelines would be great. Jamie, we can put something like that together. I can get you a copy of the slide that has that. Again, it's kind of a moving target because it all depends on when that offer and acceptance come through. So I can put together a very general timesheet for everyone. So got a few minutes left here. If anybody has any other questions, be happy to address those. If you just type them into the question box, we'll address those. But if not, my email and phone number are here on this last slide. If you have any questions, concerns, comments, feedback, we'd love to get that. Hope everyone found this informative. Again, I know it's a very confusing topic and this was a very brief overview, but hopefully this helps. It helps you explain homeowners' claims to your insureds and to your customers, and that it helps them kind of understand, what's happening on a homeowner claim that arises from a construction defect. So again, thank you guys all for attending. Really appreciate it and look forward to talking with many of you in the near future.